Share. There we go. All right. Now, if I could just get rid of this that's in the way. There we go. All right. Okay. It's always a struggle, but that's okay. And thank you so much, Kuka. And I want to say perhaps the best has been saved for last. I will let you all be the judge of this, those of you who have tuned in to a number of these lectures. All right. So I want to begin by discussing how this lecture came about, right? Anti-Black hair injustice, history, law, and politics. So the origins. In September 2025, I presented a paper at the Weaving It All Together Hair, Health, Law, and Policy Symposium at Drexel University's Thomas R. Klein School of Law. I had an absolute ball. It was so much fun. And the presentation, the title began Policing Black Hair, and then it morphed into Anti-Black Hair Injustice under the system of integration once I finally presented the paper. Now, the paper has evolved into Anti-Black Hair Injustice under the system of integration, and I will be submitting that paper for publication soon. And the paper has morphed into a proposed course in the Department of Black Studies, Anti-Black Hair Injustice, History, Law, and Politics. And I should be hearing word within the next few weeks, months, about whether or not the course has been accepted. I am optimistic. All right, so let's get right into it, right? So anti-Black hair injustice is aligned with the centuries-long project of anti-Blackness that begins with the transatlantic slave trade and the system of enslavement. So here are remarks by President Lincoln in 1858 in Charleston, Illinois. And this is towards the end of this photograph. Quoting the president, "And I will say, in addition to this, that there is a physical difference between the white and Black races, which I believe will forever forbid the two races living together on terms of social and political equality. And inasmuch as they cannot so live, while they do remain together, there must be the position of superior and inferior. And I, as much as any other man, am in favor of having the superior position assigned to the white race." End quote. We can recognize President Lincoln's hand in abolishing slavery while also recognizing his clear white supremacist beliefs. Even with abolition, he still believed that Black people were inferior to whites. By connecting racial ideology to genetics, President Lincoln argued that Black people were not worthy of the social and political rights that white people enjoyed in 1858 and beyond. His beliefs foreshadowed Jim Crow segregation, as well as how Black people would fare under what I term the system of integration. Right. So the white supremacist ideology that President Lincoln embraced was hardly new. European philosopher Voltaire refers to people of African descent as possessing, and I quote, "round eyes, squat noses, and invariable thick lips, the woolly heads, and the measure of their intellects." End quote. According to Voltaire, these characteristics were forever inferior. The woolly heads signaled how conceptions of beauty were mapped onto racial ideology. Therefore, hair was key in framing Blackness as inferior. And as you can see on the PowerPoint slide, sociologist Orlando Patterson has argued hair, not skin color, became the real marker of servitude during the enslavement era. And more recently, Jasmine Nicole Cobb goes further than Patterson in her brilliant analysis by showing how Afro-textured hair was central to the subjugation of enslaved Black people. Now, here's Frederick Douglass, the great abolitionist. And look at that hair, the woolly hair, right? According to Voltaire. So in Frederick Douglass's second biography, My Bondage and My Freedom, published in 1855, a hypothetical scenario and question is posed, with hair taking center stage. Quote, if the legislature at Harrisburg should awaken tomorrow morning and find each man's skin turned Black and his hair woolly, what could they do to remove prejudice? Immediately pass laws entitling Black men to all civil, political, and social privileges, was the instant reply, and the questioning ceased, end quote. Now, this quote is from the introduction of My Bondage and My Freedom, written by Dr. James McCune Smith, a prominent Black physician, abolitionist, and writer. Dr. McCune Smith challenged the very anti-Black racist ideology peddled by Voltaire, President Lincoln, and other white supremacists. So now we're getting to freedom and the turn of the 20th century. So in the aftermath of slavery, at the turn of the 20th century, anti-Black hair messages persisted. Specifically, Black hair was framed as deficient and in need of change. Anti-Black hair care advertisements targeting Black women in particular urged them to change the woolly hair that pervaded Enlightenment and antebellum era discussions. Within Black communities, something else was afoot. The dawn of the 20th century marked the first century that slavery had not existed in the nation. Black people approached the new century with hope and optimism that they could and would secure political and economic rights enjoyed by white people for centuries. Appropriate grooming practices were a key site in the fight for racial progress. Black people from all classes, not just the middle class, believed that pride in appearance would lead to racial advancement. Part of this project was a middle class-led politics of respectability. Black people embraced a politics of respectability as an anti-racist project to reject stereotypes and caricatures of Black people and culture. Black people stood up and said, we are not what white supremacy makes us. Straightened hair was part of that project and became associated with racial pride and respectability, but not by all. There were critics. Nanny Helen Burroughs, who you see on the PowerPoint slide here in 1909, a member of the National Organization of Colored Women, argued, and I quote, what every woman who bleaches and straightens out needs is not her appearance change, but her mind changed. If Negro women would use half the time they spend trying to get white to get better, the race would move forward, end quote. Her friend and contemporary, Tuskegee University founder, and arguably one of the most influential Black leaders of his day, Booker T. Washington, agreed. And you see Washington here in 1905. Oops. Oh my goodness. Here I go again. Jeez. Continue share. All right. It's gonna go here. Here we go. All right. In fact, Burroughs and Washington were directly critical of beauty moguls, Madam C.J. Walker and Annie Turnbull Malone, for producing and selling products that straightened Afro-textured hair. Walker rebuffed her Black critics. She let them know something. She said, and I quote, "Right here, let me correct the erroneous impression held by some that I claim to straighten hair," end quote. She told a reporter in 1918 after she had been called the quote unquote de-kink queen by a white newspaper. Madam Walker continued, I quote, "I deplore such an impression because I have always held myself as a hair culturalist. I grow hair," end quote. In addressing her white and Black critics, Madam Walker argued, unlike the anti-Black refusal to recognize the beauty that Black women possessed, she never took Black female beauty for granted. Black women were beautiful. Walker's goal was to enhance Black women's beauty and also produce products that would assist in promoting healthy hair and scalp for Black women. A number of other hair care companies did the opposite by not only engaging in anti-Black advertising, but also selling products targeted to Black women that were laced with toxic ingredients. Ooh, I changed it right this time. Right on, I'm on a roll. So now we're at the civil rights, Black power era, mid-century, mid-20th century. Wearing one's hair natural, specifically the afro or natural, presented a counter to the decades-long tradition of Black women straightening their hair. With the declaration, "Black is beautiful," a generation of Black people stood up as the Black Power movement embraced a Black beauty pride in the mid to late 1960s. The monikers Negro and colored were associated with Eurocentric standards of beauty, an outdated Blackness. Still, the Afro presented paradoxes, with gender at the epicenter. In the article Nap Time, Historicizing the Afro, historian Robin D.G. Kelly notes, and I quote, "The Afro was deeply embedded in a larger racial and gender discourse about the Black body under racism and sexism. For Black women, more so than Black men, going natural was not only a valorization of Blackness or Africanness, but a direct rejection of a concept of a conception of female beauty that many Black men themselves had upheld," end quote. In agreement, sociologist Maxine Craig argues, and I quote, "Men had masculinity to gain and nothing to lose by wearing their hair natural," end quote. Still, under what I term the system of integration, Afro-textured hair worn by all Black people, regardless of gender or non-binary, gender non-conforming status, would be marked as a problem. But Black women would bear the brunt of these cases and in court to boot. All right. All right, and this is really the crux of the paper that will be published. So, what do I mean by the system of integration? And it's a structure that operates to maintain white privilege in service to anti-Black racism. And let me flesh that out a bit. Right? Black people have brought what Enlightenment era philosopher Voltaire and your favorite founding father, Thomas Jefferson, termed our woolly heads, our ugly heads, to formerly all white spaces. For Black people, it is our politicized Afro-textured hair with roots in Black power, Black pride, and Black is beautiful that we bring to these spaces. It is within this context of interracial contact, under what I term the system of integration, that has made it difficult for white-centered spaces to accept a Blackness that is viewed as a threat to white privilege, white sensibilities, and white beauty standards. Here's the belief shared by far too many people. Not only have Black people received jobs that we have not earned or have been admitted to schools without merit, we are also bringing Afro-textured hair and hairstyles to these formerly white-only segregated spaces, such as the federal workforce, private sector jobs, other businesses, and schools. Thus, Black people had to contend with anti-Black actions steeped in Jim Crow segregation practices that message whites only through the policing of Afro-textured hair. This "no Blacks allowed" messaging is seen in the rise of anti-Black hair injustice in the courts during the post-civil rights integration era. In fact, I argue that anti-Black hair injustice is a perfect example of how the system of integration maintains anti-Black discrimination in spite of Title VII protections in the 1964 Civil Rights Act that make it illegal to practice racial and gender discrimination within employment. Still, since 1981, courts have essentially ruled that whereas Black people are born with Black skin, we do not come out of the womb with braids, twists, cornrows, and dreadlocks. Social scientists have convincingly argued that race is a social construction, though with real material consequences for all of us, Black, white, brown, etc. I argue that Afro-textured hairstyles are important cultural constructions with real material and emotional consequences for Black people, with women shouldering the lion's share of this burden through court cases in the post-civil rights era. For example, in 1970, Beverly Jeanne Jenkins charged, and I quote, her former employers, Blue Cross Blue Shield, with denying her promotions and better assignments, and with ultimately terminating her employment because of her race, sex, Black styles of hair and dress, in violation of Title VII of the Civil Rights Act of 1964, end quote. In essence, Jenkins brought an intersectional complaint against Blue Cross and recognizing that as a Black woman donning an Afro hairstyle, she was the victim of discrimination because of her race and gender. The court agreed, ruling, and I quote, a layperson's description of racial discrimination could hardly be more explicit. The reference to the Afro hairstyle was merely the method by which the plaintiff's supervisor allegedly expressed the employer's racial discrimination. That's a powerful statement, end quote. However, the intersectional ruling in Jenkins did not set a precedent. Aish. When the next case was decided in 1981, Renee Rogers was not so lucky. The court ruled that American Airlines and Rogers' manager did not violate her civil rights under Title VII as a Black female employee. But there was something else afoot in 1981 when the Rogers decision came down. And now we get to this pendant or this button on the PowerPoint slide. In 1980, Republican presidential candidate Ronald Reagan ran on the slogan, "Let's make America great again." Unlike Renee Rogers, Jenkins's case began during a moment, 1970, when the civil rights Black Power era was still fresh on the minds of the nation. A mere decade later, racial and gender justice amnesia set in. Under President Reagan's Let's Make America Great Again agenda, the Civil Rights Act of 1964 was less than 20 years old, and rollbacks were already beginning. And anti-Black hair injustice has been a key site for racial discrimination against Black people. This is why the Civil Rights era is referred to as the Second Reconstruction. Black people were given a taste of justice, of freedom, abolition, here in the form of Title VII. And yet, even the system of integration itself reminds us, once again, that Black rights do not matter, and anti-Black hair injustice is a perfect example. The message, let's make America beautiful again, resonates here. I argue that a connection existed between the climate in the wake of Reagan's election and his politics and the rise of anti-Black hair injustice in the courts. This continues under President Trump's Make America Great Again agenda. In fact, Black hair discrimination has been steady in the courts, regardless of who has occupied the White House since 1981. This is why there has been an urgent need for creating a respectful and open world for natural hair, also known as Crown Act legislation. And this is thanks to Professor D. Wendy Green's insightful legal scholarship on Black hair discrimination and her activism in authoring federal and state Crown Act legislation. 1,000 thank yous to Professor Green. The cases from 1981 to 2023 challenged the system of integration through civil rights law, specifically Title VII, and Black women argued that they were discriminated against based on their race and sex. Hence, they understood, Black women understood Title VII and used an intersectional argument to bolster their case. Here's another example, more recent one. Although in Casey versus City and County of Denver in 2023, alleged discrimination based on the Americans with Disability Act, the suit also contained a Title VII complaint alleging discrimination based on race, sex, and the intersection of race and sex. Cassie charged that she was subjected to a hostile work environment. Anti-Black hair injustice was at issue here as well, thereby once again illustrating how discrimination against Afro-textured hair and hairstyles serve as a compelling example of the continuing significance of anti-Blackness under the system of integration. Now, here are some facts in the case. Charmaine Cassie, a Black woman, was hired as a probationary firefighter in the Denver Fire Department, DFD. Court documents note that a DFD captain advised Casey, and I quote, to keep her head down and be like a slave if she wanted to get through the academy. The captain stated that he had given Cassie the advice because she was a quote unquote minority. The anti-Black comments did not end there and soon intersected with her being a woman. I'm quoting once again. Chief Carly Helwick said something to Miss Cassie to the effect of, quote, you know, it's not that people mean to, but when you have one thing that's not like the other, it's just certainly going to be singled out, you know, looked at differently. Plus, you're female, so you will get singled out, end quote. Chief Fulton then added, and I quote, it's just human nature for people to be like that. I don't think we mean anything by it, but it happens. People are always going to single others out, especially when they are different, end quote. Chief Fulton also said that Miss Cassie, and I quote, did not look like us, end quote. Miss Cassie understood Chief Helwig and Chief Bolton's comments to be directed at the fact that Miss Cassie is Black, end quote. Now, these comments support Cassie's claim of discrimination under Title VII, as both chiefs riff on the popular Sesame Street song, one of these things is not like the others. I know many of you out there know that. Though in service to an intersectional Blackness, court documents note that in seeing Cassie wearing her hair straightened rather than twist in braids, Chief Helwig commented that Cassie, and I quote, actually looked human, end quote. Voltaire, Lincoln, Jefferson. Helwig engages in a centuries-long anti-Black narrative that equates Blackness with being inhuman, inferior, but does so through hair. Straightened hairstyles are associated with humanity, and Afro-textured hairstyles with being uncivilized and essentially animal-like. It's the woolly hair. In addition, Helwig's comments show that Afro-textured hairstyles, such as braids and twists, are demonized. Still, it is also worth noting that wearing her hair straightened did not protect Cassie from anti-Black comments about her hair. In fact, the anti-Black hair discrimination did not end with Cassie. Court records also point to the experiences of a Miss Allen, the only other Black female recruit along with Cassie. Quoting, when Miss Allen began the academy and went to pick up her uniform at the warehouse, the DFD captain there told Miss Allen something to the effect of that he knew how, and I quote, you people are always putting those things in your hair. And I feel like you need to really rethink that and think about what you're going to do with it. End quote. In addition, Tarnia Clark was the first Black female engineer hired at DFD, working there for 14 years. She reported experiencing discrimination when she joined the academy, and it would persist after she graduated. Clark explained that her experiences, along with Cassie and Allen, made it clear that Black female recruits and probationary firefighters were being targeted. Clark's recounting of the following is yet more evidence of anti-Black comments. Miss Clark further had, and I quote, Miss Clark further had issues with a firefighter who always made comments about her hair being disgusting and offensive, end quote, which other firefighters observed. At the time, she was wearing her hair in braids, which is a common style for Black women. The court ruled in favor of DFD, dismissing Cassie's charge of race, sex, and intersectional discrimination under Title VII, as well as the hostile work environment charge. Given this example, I need to make the following point, as it has been central to my career-long research on Black women and girls' relationship to hair. Black women, regardless of our hair texture and hairstyle, catch hell given how intersectional justice operates. A recent study found that 300,000 Black women have lost federal jobs in the wake of Make America Great Again 2.0. That hurts Black people. It hurts Black families. It hurts Black communities. It hurts these Black women. I have no doubt these women wore their hair straight, straightened, Afro textures with all types of styles, fried, dyed, and laid to the side, as I heard growing up. But there has never been a need to lobby for legislation to protect the right to wear straight and straightened hair because of how it is received and welcomed by the mainstream and under the system of integration. In other words, how it is received, yes, how it is received under the system of integration. The Sea of Crown Acts that we are witnessing across the United States is blatant evidence of why protecting Afro-texture hair is a civil right. But along with making that argument that Black people do not come out of the womb with Afro-textured hairstyles, courts have also based their rulings on plaintiffs violating company grooming policy. The grooming policy argument has been used to foster anti-Black hair injustice in schools in the most recent history, with Black girls and boys being punished. So let's consider the Daniel George federal lawsuit. And you see Daniel George here in the photograph on the PowerPoint slide. So Texas was the 24th state to pass a Crown Act effective September 1st, 2023. 2 weeks prior to the Crown Act going into effect, George was a 17-year-old junior at Barbers Hill High School in the Houston suburb Mount Bellevue. And he was suspended for violating the district's hair grooming policy. The district argued that his dreadlocks fell below his eyebrows and earlobes, thereby violating the district's policy on hair length for male students. But as you can see in the photograph, his dreadlocks were styled up. However, aware of the school policy, George wore his hair tied up on the top of his head, well above his eyebrows, earlobes, and collar. The policy also sets standards for all students, with policy noting that hair must be, and I quote, clean, well-groomed, geometrical, and not an unnatural color or variation, end quote. George refused to change his hair, and prior to being suspended, was punished by having to sit on a stool in a cubicle during the course of the school period. By August 31st, 2023, he was suspended. Darryl George's experience with anti-Black hair injustice made local, national, and international news. On September 23rd, 2023, George and his family filed a federal lawsuit charging discrimination as stipulated in the Crown Act. In November 2023, the school district filed a declarative judgment lawsuit requesting a judge to weigh in on the matter of a hair policy for males as being in violation of the state's Crown Act. Several months later, on February 22nd, 2024, a judge ruled in a bench trial that the school district did not violate the Crown Act by repeatedly suspending George for not complying to Barber Hill High School's hair grooming policy regarding hair length for male students. Once again, the court examined a case of anti-Black hair injustice through a colorblind lens, with the matter of hair length masking as a reason to do so. George's mother even reported talking to the school principal prior to her son attending the school. George made sure how he styled his hair was not in violation of the school's hair length policy for boys. Yet, he was denied a right to wear his natural, protected hair under the Texas State Crown Act. George was treated poorly because he refused to abide by anti-Black hair discrimination that is a proxy for racial discrimination under the system of integration. In conclusion, anti-Black hair injustice is racial injustice, and employers, schools, and the courts have found a way to circumvent, go around Title VII and even Crown Act legislation, as we see with the Darryl George decision. But we desperately need state and federal Crown Act legislation. And we need the legislation to be enforced. We need the law to be enforced. Anti-Black hair injustice is yet another cog in the wheel of anti-Blackness under the system of integration. So now, as we conclude, I want to give some thank yous, some shout outs, some big ups to the Office of Admissions at UCSB, Kuka Costa and Marcus Mathis, my dear friend Kelly Kirkland at Netflix, who got the word out about this lecture, the Division of Social Sciences and Department of Black Studies at UCSB, always supporting a sister, and to everyone taking the time to view this lecture live and those watching, rewatching on the UCSB Admissions Office YouTube channel in 1 week. And one of the things that I did, I often do at the end of my courses, and I certainly did this at the end of the winter quarter this year. I played A Change Is Gonna Come, Sam Cooke's 1964 song. And Cooke writes this song because, like so many in the nation at that time, in fact, so many around the world, were seeing images of peaceful protesters during the civil rights movement in this country being met with violence. So Cooke writes, A Change Is Gonna Come. And what I told my students last month was that we are in a perilous time in this country, in this world. But a change is gonna come. We've seen it before. We will see it again. I don't know when that change is gonna happen, but I know it's gonna come. So I will now stop the share, and hopefully I can be seen